SJC-12430, Commonwealth v. Justino Escobar.
Mr. McKenna, good morning.
Good morning. May it please the court, James McKenna for Justino Escobar. Thank you very much for granting direct appellate review in this case where we seek extraordinary relief in these very extraordinary circumstances. I'd like to start by discussing the relevant test. For two reasons, basically. One, because it's good to start with the relevant test. Also, because it cuts very favorably in favor of Mr. Escobar. That test is an investigation is required if a chemist may have compromised the integrity of the Commonwealth's evidence. That's what we have here. Ms. Saunders, the chemist in Mr. Escobar's case, reported results that were higher than what her coworkers said was possible, 50% higher. The Commonwealth's appendix discusses the idea that has a statement by Lisa Glazer, a chemist from the Hinton lab, saying that before Melendez-Diaz, max 400 reports per month. At the time we're looking at, the time in 2003, 2004, when Ms. Saunders was reporting results with Annie Dugan and Sonia Farrak, she averaged 608 reports per month. She had 558 in March of 2004, the month that Sonia Farrak, not Annie Dugan, set the record at the Hinton lab.
Is that the only showing you have of possible misconduct? Is that all we have? The fact that she tested more samples?
We have what Judge Roche referred to as very high numbers, and that should trigger an investigation. That indicates
she's ordered follow-up on that, hasn't she? She's ordered follow-up discovery on that.
And denied our request for investigation.
And has done what?
Denied our request for an investigation. She required that some materials be produced and said there should be no investigation at this point.
It was denied without prejudice, I believe.
Yes, Your Honor.
So with the view that I'll see what the discovery uncovers, and then arguably you could revisit it that time.
Yes, Your Honor.
And why is that not an appropriate course of action?
Because we're now 5 years after the discovery of Sonia Farrak's malfeasance in 2013. January 18, 2013, they find out that she has engaged in malfeasance. There's been no investigation at this point. No investigation to this point, and this court in 2015 said in the Ware and the Cotto cases, there must be. The rights of defendants to exculpatory evidence require that. There still hasn't been.
That was as to Farrak's conduct in Amherst.
Yes, Your Honor. And
this is in Hinton.
Exactly, Your Honor.
This is as to Ms. Saunders as opposed to, so I mean, I gather all you have on Saunders is she has a greater than average number of tests that she has done, but well below what Dugan did.
She had, Dugan, Farrak, and Saunders produced 52% of the results at Hinton at the time the three of them were testing. 52%. There were 10 other chemists reporting results. What we're saying is there should have been an investigation at that time. To this day, there's been no investigation of Ms. Farrak at Hinton. There's been no investigation.
You keep singing the Farrak song. Sing the Saunders song.
Thank you, Your Honor. Very high numbers. In the context of Ms. Dugan's...
Putting those in context as your brother does, he says it's actually not an increase, that Saunders was so high, it's that Dugan's actually went down.
If I can answer that in terms of an analogy, Your Honor.
Yeah.
If I had a client who was accused of armed robbery in 2004, and I went to the Commonwealth and said, I can prove my client did not commit armed robbery in 2010, will you dismiss the case? Commonwealth would reject that argument out of hand because it's unfounded. They're making that argument here. They're saying that if you average all the numbers of Saunders up until 2012, they're low. In 2004, when she's testing with Farrak and Dugan, the numbers are impossibly high, according to her coworkers. That's what we're talking about. We're talking about not just higher than average, they're impossibly high. And that should have triggered an investigation.
Well, you say they're impossibly high. What is the evidence that they are impossibly high? She's much more experienced than Dukin was or Farrak was, and her numbers are well below Dukin's numbers. So where in the record do we find that it was impossibly high?
In that time frame, they're below, but not that much below. During that time frame, I believe Farrak is at 5,800, Dukin's, I believe, at 4,600, and Saunders at 42, in that time frame.
Mr. Demore says it's 65% more than Saunders, that what Dukin did over a certain period of time.
And he's
You're choosing a certain smaller period of time, but he says, well, that's when Dukin's numbers dropped.
He's using the whole time frame up to 2012, which goes to the idea of armed robbery in 2004 versus 2010. If there was no dry labbing by Saunders in 2010, that doesn't mean it wasn't happening in 2004. There should have been an investigation, and there hasn't been an investigation. High numbers in the context of Dukin's malfeasance should have triggered investigation. There still hasn't been one to this day.
So I'm trying to figure out what you're precisely saying. So you were saying that based on those numbers alone, the judge abused her discretion in deciding that I'm going to allow more discovery, but I'm not at this time going to order an investigation similar to Cotto.
And denied our motion relative to dismissal. Ultimately, the question before this court concerns dismissal versus investigation. In 2015, in Cotto and Ware, the court said there must be an investigation if there is evidence a chemist may have compromised the evidence. That's well-founded, and that applies here. That should have been done here. It hasn't been done.
Aren't you missing the other piece of Cotto? That it said there should be an investigation of Farrak because of the allegations raised about Farrak? Not that there should be an investigation when a defense attorney says there's problems with the chemist. That's not what Cotto holds, does it?
It doesn't. But it holds that if there's evidence the chemist may have compromised, there should be an investigation. And that's the duty to investigate, drawn upon the duty to learn and disclose. And that, respectfully, is what we have here. There should have been some investigation relative to, and I know I'm singing the Farrak song. There should have been an investigation relative to Ms. Farrak. Inexcusably, there hasn't been, where she has, according to Judge Carey's findings, she was engaged in malfeasance even before.
But you're aware that that's the subject of separate litigation?
With respect to the separate litigation concerning the Amherst matter, not the Farrak, to my understanding, Your Honor, not the Farrak-Hinton material, where there has been no...
But how long had Farrak left Hinton before your client's samples were tested?
About 4 years, Your Honor.
So she had left 4 years before, and so how is her presence going to have tainted the samples done 4 years after she left Hinton?
The Farrak matters to our case in that it shows there was no investigation. Had there been an investigation relative to whether any other chemists were doing what Annie Dugan was doing, they would have found Farrak. Farrak, who outproduced Dugan at the time they worked together. According to the CPCS filing in this case, there's indication that Farrak and Dugan were dry lapping at the same time, back in 2004. At the same time, Saunders was producing results which, again, were higher than her coworker believed the maximum could be. 608 results versus 400 maximum. That's where we are. Very high numbers without any investigation. And in terms of that, in terms of Your Honor's question, initial question as to the misconduct, we all accepted the Inspector General's, I'm out of time, report until we had the findings of Farrak's meth use at Hinton come in June of 2015. Between March of 2014 and June of 2015, everyone accepted what the Inspector General said about Farrak, about Annie Dugan being the sole bad actor at Hinton. We get these reports saying she's using meth at the prior lab, which was Hinton. If she's using meth, what did they do in terms of that? Double-check the Inspector General's report. There's nothing there. And the footnote on page page 10, footnote 10, footnote 14, indicates that they didn't realize she even worked there. So the Inspector General who says Annie Dukin's sole bad actor, necessarily implicit in that is the idea that they looked. If you do an investigation and say only Annie Dukin was a bad actor there, that implies necessarily that that in that investigation you looked as to whether there were other bad actors. That didn't happen. And I'm sorry I'm out of time.
Thank you.
Thank you very much.
Mr. Demore?
Good morning, Your Honors. May it please the Court. Vincent Demore on behalf of the Commonwealth. When I was a paralegal before I went to law school, I worked for an attorney in construction practice, and he told me once that numbers are like political prisoners, and if you torture them long enough, they'll say anything. And this case reminds me of that. There's no evidence outside of those higher numbers that Ms. Saunders engaged in any wrongdoing whatsoever. On the face of that, we have several investigations, which I like to look at as one large investigation in essence. First begun by the Attorney General, then the Inspector General, and lastly, pardon me, Attorney Caldwell's investigation of the situation in Amherst and, pardon me, Sonia Farrak. And when we look at all of that put together, through the course of that, at no time was there any indication whatsoever that Ms. Saunders engaged in misconduct. Her numbers are higher than some of her colleagues. I think that should be expected, given her depth of experience, and they're still not nearly as high as Ms. Dukin's numbers. And I lay that out in the brief with the charts and the graphs that I provide, and I stand by those in terms of the accurate picture I think it portrays. So when we talk about how when my brother indicates that there had never been an investigation of Ms. Saunders, I have to reject that. There has been an investigation by the Attorney General, by the Inspector General. All of that put together, I think, paints a full and complete picture of what occurred at the Hinton Laboratory.
The concern I have is I went back to look at Ms. Saunders' interview. I think it's 243 to 244. Nobody asked her about her productivity. Nobody asked her to explain how come her numbers were higher than all the other chemists other than Dukin. What should we do about that?
And that's the interview conducted by the state police.
That's I think I can't tell if it's the IG. It's the only interview to my knowledge that we have of Saunders.
Well, so that would be that conducted by the state police in the summer of 2012.
That's state police as opposed to the IG?
Yes.
So the IG never questioned her?
I do not believe that to be true. I do not know that to be true. The Inspector General interviewed, I think, 40 witnesses in total. Inspector General investigations are confidential by their very nature. The CMRs dictate that information is not publicly disclosed. They produce a report at the end of the day. I find it very difficult to believe that the Inspector General, who reviewed 200,000 documents, did retesting on over 1,000 samples, and by the terms of its investigation, did a full and complete investigation, top to bottom was the phrase used, to discover if anyone engaged in any misconduct or malfeasance of the lab. I find it difficult to believe that they did not interview Ms. Saunders, but I do not have any information affirmatively one way or the other with regard to that. But when we talk about what sort of numbers are appropriate numbers too, I think it's important to look at those where those statements come from in the various interviews. As I read them, you have some varying answers with respect to that. Some people say 400, some people say 200. I don't think anybody knows when asked what's an appropriate number. I think people ask themselves, well, gee whiz, what was the biggest number I ever produced? And that would be an appropriate number as the top that somebody could produce. I think that's a very human reaction that I'm going to be among the highest, that if people are higher than me, that's impossible. So, as a point of fact, I'm not sure we really know exactly what is a unnaturally high number. What we do know is what should happen over time. And I think Ms. Saunders' numbers, when placed in the full context of the lifespan of her work, make sense. They're steady year over year over year over year until Melendez-Diaz, and then they begin to decline. What's so striking with Ms. Dukin's numbers, and I'll concede they're high numbers, and they're always high numbers, but for me what's most striking is following Melendez-Diaz, they skyrocket. and are much, much higher than they've ever been before when your time at the bench should be decreasing, especially someone who's producing so much should be, in theory, called to testify more often. And you don't see that same pattern with Ms. Saunders. You see a diminution. And in any event, if there is, in fact, some issue with Ms. Saunders, the defendant has an opportunity to investigate that with what I anticipate will be an evidentiary hearing in the Suffolk Superior Court with the discovery he has. The appeal here is entirely premature. And this is really the definition of piecemeal appellate litigation, because we're going to be back either here or upstairs sometime in the next year or so in the event that there's a hearing in Suffolk Superior Court. I think those questions need to get flushed out fully, the factual basis, before any legal questions surrounding it can be answered. But with respect to what I view as the relatively limited questions before the court here today, whether or not an adequate investigation has been conducted, I think the answer to that is yes, when one looks at the full corpus of everything that has been. And then secondly, whether or not the Inspector General engaged in misconduct, which is the allegation here, is that they intentionally misrepresented what their findings were with the hopes that all of us would rely upon them. I think the answer is clearly no. And I don't think the judge abused her discretion below when she found that there was no evidence to support the proposition that the Inspector General engaged in misconduct.
So in terms of what is before us, the issue before us is, did she abuse her discretion in denying the motion to dismiss? Did she abuse her discretion in denying, without prejudice, the motion to dismiss, and denying without prejudice the motion requiring an independent investigation?
Yes.
And in lieu of all that, granting further discovery?
Yes. And I think not only is it impossible to say that she abused her discretion, I think that is an entirely appropriate way to handle this, is to see what we have, develop a full record, and move from there. I'm not candidly convinced that had she ordered some further investigation, I don't believe that in her position she was empowered to do so. This court obviously stands in a different stead. And I'll note, this court didn't order an investigation. The court gave the government a choice between conducting an investigation or else with respect to how Cotto was going to shake out. And how the else would go, I'm not sure. But it was not ordering an investigation. It gave 30 days to decide whether or not we would conduct an investigation. And that's a very different...
We try to be as pleasant as we can.
You've always been so with me. And that's a very different kettle of fish. And there's separation of powers issue at work there and the like, and it's, choices and consequences. It's, whether or not the government does engage in some investigation is a separate question. But I think the judge would not have been empowered to order an investigation in any event. And again, I would, not to beat the dead horse, but I would submit, when one looks at the full body of work that was done with this multi-agency investigation, there really has been a full investigation with respect to the Hinton Laboratory. The Inspector General's investigation was called for by various stakeholders in the criminal justice system, from the defense side, from the government side, and I think that their work is viewed in high regard. I think that the Inspector General carried out their statutory mandate with the work that they did. This is the sort of spiritual successor to the Ward Commission, not an organization that's afraid to ruffle feathers, not an organization that is concerned with offending others with regards to their findings. And in many ways, they really are incentivized to find that misconduct, whereas the rest of the government is left with the task of dealing with the aftermath. The Inspector General, in some ways, and don't let me sound glib, gets to kind of roll the grenade in the room and shut the door with respect to their findings and not have to deal with what comes afterwards. So I think there's no incentive for them to minimize the misconduct. And when you read that report, I don't think they pulled any punches with regards to the issues that they found at the Hinton Laboratory. I just think they simply did not find any misconduct on the part of Ms. Saunders. And I'll also note, for whatever it's worth, the narcotics in this case have been reanalyzed by the state police, and they are what we've always purported them to be, which is cocaine. And it's also consistent with the facts of this particular individual case, where it was found in a hide inside of a motor vehicle where the defendant acknowledged at least some portion of cocaine also recovered in that car was his for his personal use. So for whatever that's worth, I think...
I can't remember, in either Cotto or... We sort of ordered the availability of testing. I'm just right, in one of those cases?
Yes.
Is this drug sample still available?
Yes, and has been retested in
Has
in
been
December.
retested?
Yes.
And it was cocaine?
It was. It's the very last 2 pages of the record appendix I submitted. It's not, I think the court still has before the question of whether or not to accept that as part of the record, but when I was asked to handle this matter, I asked that it be retested. If the court has no further questions, I'm happy to rest on the papers.
Thank you.
Thank you.